licensed attorney in the state of Colorado. I'm also an executive. I'm the Chief Operations Officer of Johnson Law Group, and today I'll be presenting on collaborative law as a means of obtaining a confidential divorce and how this process protects executives from public litigation, equity disputes, and reputation risk. Let's get into it. Why should an executive give thought to the collaborative law process? When you are involved in litigation through the court system, most everything by default is public record, meaning that with payment of a small fee, or if someone's got a bunch of time on their hands, they want to drop into a courtroom, anyone can gain access to the most sensitive details of your personal life and your professional career. So the benefits of the collaborative law process are many. As you can see here, 90% of collaborative cases settle without ever filing public motions. The average collaborative divorce is 4 months long, as opposed to the typical court-based divorce timeline, which takes about 12 to 18 months on average. And with the collaborative process, you're not paying filing fees. You're not just sinking your money into some administration for the court system. You also get the benefit of a single dedicated team of professionals who are working together to resolve your matter, rather than the traditional adversarial process. For executives, board members, partners, the confidentiality and control of a collaborative divorce often outweighs the cost premium that comes with engaging in that process. All right, so what are we going to cover today? We're going to talk about what collaborative law is, why execs choose it, the team you can expect to work with, and when collaborative law works and when it doesn't work. Let's start with what collaborative law is. What is it? It is a binding commitment to resolve your divorce outside the courtroom. A little bit more details here. When we say binding agreement, we mean that you're entering into an enforceable contract to maintain privacy and keep your matter out of the court and public eye. You're also committing to full voluntary financial disclosure. This is part of any divorce process, public, private. You do have to engage in financial disclosures. That means that you are outlining the assets you own, the debts that you owe, your income, your expenses. Both parties are engaging in that process without fighting back. You're also agreeing to joint retention of neutral experts and no threats of litigation during the process. That's a big no-no. If either party can't abide by the terms of this agreement, then all professionals withdraw, and you have to go the traditional courtroom route. So what are the key differences between collaborative, that process, and the traditional courtroom approach? Well, under the traditional model, so if you're going to the courtroom, you're having public filings, you typically only ever encounter one true neutral, and that's your mediator. Rather than having a team of neutral, those neutral experts to support resolution of your case. Another difference is outside of mediation, there's a lot of ad hoc negotiation. That negotiation might result in settlement, might not, but you really only have one dedicated session of mediation specifically to try to resolve your case. Litigation, like we've mentioned, is also public and adversarial, and it's oftentimes judge decided. So you've got a stranger in a black robe who's going to decide your fate after hearing about it for maybe altogether 10 hours, 20 hours of time in their lives, as opposed to you being in control of your dissolution. Under the collaborative model, you experience a private team-based approach. The financial, emotional, and other experts are integrated into the process. So it is contemplated at the outset that you are going to select these neutrals together, and they are going to help you process your case. It's also much faster than contested litigation, and it's designed to help you reach an agreement with the other party in a manner that prioritizes co-parenting when it's relevant and financial integrity. The sort of punitive disqualification clause, it encourages commitment, right, to the collaborative process. The collaborative process costs more than engaging in mediation, but much less expensive than full-blown litigation. All right, so why do executives choose collaborative law? 5 big reasons. Top 5. Confidentiality, control over the timeline, equity, tax optimization, and reputation. So starting from the top, there's no public court motions, no transcript of testimony or evidence. You're not creating these discoverable and public events and materials that can be distributed outside of your relationship and the professional team that you're engaging in. So you don't have that publicity in the same way that you do on the public record. Your settlement terms remain private, and it's especially important to executives with a public role, right? There's public visibility or there's a board role to keep these things private. You don't want them to come out into the public and impact the interaction in your professional career. Moving on to the next item, the team is going to work based on your schedule rather than the judge's calendar and availability. One of the things that we encounter most frequently in our courtroom-facing cases is our parties might be ready to litigate. They might have a disputed issue and they've done what they can for negotiation. It is time to get this third party involved, and you can't schedule for 6 months. You have to wait for the judge to be available to you. That's not going to be the case when you have a team that's dedicated to your matter. So the process is much faster. Everyone's working in concert rather than that adversarial approach. With joint experts, complicated financial aspects of divorce settlements can be handled with knowledge and speed. And there's also expertise in the room at the start when it comes to reviewing the tax implications of your matter. Otherwise, you're hoping that an attorney and a judge can figure it out on their own. And with no public record, mentioned this before, alluded to it, you can manage your reputation with more control and confidence. Who is a part of your collaborative divorce team? By default, a handful of people. So you have the collaborative attorneys who are trained in the process and are not working in an adversarial matter, which is what you find by default when you're in the courtroom process. And if for whatever reason the collaboration fails, these attorneys are disqualified from representing either party in future litigation. You also get a financial neutral with the right licensure and expertise to handle the complex financial records and implications of your case. The mental health professional assists with caring for you and your emotional well-being throughout the process, regardless of the reason for your divorce. It can be really difficult to go through this process. And when you're working with a collaborative team and you have this neutral, you have someone who understands where you're going from beginning to end, which is really helpful. And then, of course, as relevant, your team may include a child specialist who protects and advocates for your shared children. Does the collaborative divorce process work in all cases? No. Like any tool, it's best deployed in some circumstances over others. So let's go through that. When is it the right tool? Well, it fits in these circumstances most frequently, where either spouse has significant career or board exposure, equity, partnership interest, or business ownership is in play. Both spouses want a private, non-adversarial process. There are children involved and co-parenting will continue. Tax planning is material to the outcome, and both sides are willing to disclose fully without compulsion, without a court order saying you must do this. When doesn't it fit? Documented domestic violence or coercive control. Those circumstances don't align well with a collaborative approach. If a spouse is hiding assets or refusing voluntary disclosure, where there is a significant power imbalance one side can't overcome, if there's an active criminal investigation involving marital finance in particular, if there's one spouse that is committed to a litigation strategy, they don't really want to be collaborative, or if there are urgent safety or emergency relief that's necessary in your case. So that is a really high level view of collaborative divorce. Again, I'm Shannon O'Keefe, Chief Operations Officer at Johnson Law Group. I have experience in collaborative law, high asset divorce, executive matters, and as does my team. We have a great group of attorneys here who can assist you with this process. We're licensed in Colorado. We have a handful of attorneys also in Wyoming, and we have experience, of course, in the Front Range and cross state, I just said. So please give us a call. We're available at 720-445-4444. We would love to speak with you. And I really appreciate everyone taking the time. Just remember, privacy, control, it's worth protecting. You can get a free consultation with us. You can schedule online or give us a call. And as a reminder, our next webinar will be with attorney Jason Thatcher. He'll be talking about the types of alimony in Colorado and how long they last. Thanks, everyone. Appreciate your time. Bye-bye.